This is Aaron Asen with Richards and Jerusik Immigration Law. I practice immigration delay litigation. Essentially what this is if the government takes too long to decide an immigration application, I help clients go to court through something called a petition for a writ of mandamus, or Mandamus Petition for short, and we ask a U.S. district judge to order the government to decide that application. So I wanted to talk to you for just a few moments about what we can expect to see in this area of immigration law with the incoming Trump administration. So first of all, we expect to see more delays, maybe even a lot more delays and longer delays. And this is primarily for two reasons. First, President Trump has expressed his desire to shrink the federal workforce, and this could very likely impact USCIS. We've already seen contractors, even under the Biden administration, being laid off. And this will simply have the effect of slower processing times and longer delays. Fewer people to process the applications, more delays. The second thing we fully expect to see is more due diligence being conducted on applications, more security checks, and even requiring interviews where interviews are not necessarily required by the statute but are optional. With all of these things together, we expect to see more delays. The second thing I wanted to talk to you about is administrative processing. In recent years, the government has taken the position that if somebody is put into administrative processing, that constitutes a final decision about a visa. Anything after that, once administrative processing is complete, and if the visa is granted, that is simply a reconsideration of the final decision of denial. The government has made this argument in courts across the country, and we fully expect to see the government continue to make this argument. Now, over the years, we've seen an increase in case law. In other words, judges have issued decisions about these cases. And while some judges have agreed with the government that being put into administrative processing constitutes a final decision, the majority of courts have held that it is not considered a final decision. Now, why does this matter? Because if administrative processing is considered a final decision, then the doctrine of consular non-reviewability kicks in. This means that federal courts can't decide these delay cases when somebody is in administrative processing. But like I said, a majority of the courts have held that administrative processing is not a final decision, and therefore the judges have the ability to hear these delay cases. Again, we expect this fight to continue. We're seeing more and more cases out of prominent courts like the District of Columbia and in California, and we expect to see this litigation continue into 2025 and beyond. If your application has been pending for a long time, or you feel like your case is not going anywhere, or you feel like it's been lost or stuck or whatever, please feel free to give us a call at Richards and Jerusik Immigration Law, and we'll be glad to evaluate your case and let you know what your legal options are. Have a good day.